We're going to have a wonderful speaker here for you today. This is Professor Josh Blackman. He was actually here last semester. I know a few of you were here, so you know this is going to be a very exciting talk. He is currently an assistant professor of law at the South Texas College of Law. He specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. He's the author of an amazing book called Unprecedented, The Constitutional Challenge to Obamacare. I do suggest to you all when you have free time to read it. It's a great read. And he's going to talk to us today about recent developments in Hobby Lobby and Obamacare. Thank you.
Oh, thank you, Jay, for that warm introduction. It's good to be back in Mauer. I am very happy to be here. I was here not even in March, and it feels like March again, so the cold weather is welcome once more. It's great to see everyone. Thank you, Professor Conkle, for taking time out of his busy day to provide some comments. My goal for today is to discuss a recent Supreme Court decision that's actually quite important, which is Hobby Lobby, which was decided last year. And I'd like to place the Hobby Lobby decision to the broader context of Obamacare and some really important issues on religious liberty that are facing our country, which courts are grappling with every single day. So first of all, this talk will not be about Obamacare, the actual individual mandate, whether it's constitutional. If you want to learn more about that, you can read my book or watch my talk from last year on this. Today, we want to discuss the contraceptive mandate. Okay, so what is a contraceptive mandate? Within the Affordable Care Act, which was this huge bill, nearly 3,000 pages in length, Congress provided that certain preventative care and screening for women have to be provided by insurance companies without any additional cost to the women. One thing which I want to stress is that this is the actual statute Congress passed, and it doesn't actually specify what's provided. All it says are certain health screenings and preventative care. And as is often the case with administrative law, the decision to define what these screenings are was delegated to the Health and Human Services, which then delegated that to the Health and Resources Service Administration, which in turn delegated that decision to the Institute of Medicine, which is a group of doctors and health professionals. And they released this regulation. And this regulation said, okay, what are these essential screening preventative tools that women need with no additional cost? They are all FDA-approved forms of contraceptives, okay? So just to stress, the actual decision to make employers provide through insurance plans contraceptives was not made by Congress, but it was delegated and turned to this Institute of Medicine, which is not a particularly big point, but often people say Congress passes contraceptive mandate, which isn't entirely accurate, okay? So what exactly are these forms of contraceptives? They're roughly 20. You can go to the CDC website if you like. I'm sure they have more important things on the CDC website today, but if you're so inclined, it includes a host of different products, none of which relate to Ebola, which we're very thankful for. Okay, so one of the interesting aspects of the contraceptive mandate was how it was perceived in the media. This is actually, it's not parody. This is actually an actual advertisement put out by the state of Colorado. And one of the major selling points to get young people to sign up for the Affordable Care Act through the various exchanges was that now women can get no-cost birth control. And if you can't read that, it says, let's get physical. OMG, he's so hot. Let's hope he's as easy to get as his birth control. So, and again, I wish this was parody, but it's not. This was an actual advertisement that the taxpayers of Colorado funded. Okay. Did it work? I have no idea. But one aspect about this is that although some women, no doubt, want to be able to provide this, many employers are not so crazy about this. Because as the law is originally conceived, the employers were on the hook for paying for this birth control. And while maybe she wants it because she's getting with this hot guy, right? Not everyone was so inclined. So this brings us to a group called the, I love the juxtaposition between the frat boy and the nuns, right? These are the Little Sisters of the Poor. They are a group of nuns whose mission is to provide care to old people so they can live with dignity and later in their life. So it's actually a very wonderful group. But among other things, they weren't too keen on providing various forms of birth control that they deemed sinful. So as the Obama administration originally designed this regulation, there was a very narrow carve-out for churches and houses of worship. Churches and houses of worship were not required to give exemptions. We're not required to give birth control. So originally, churches and houses of worship were exempt from this contraceptive mandate. But as the law was originally drafted through these regulations, religious entities such as the Little Sisters of the Poor were not covered. Okay? They were not covered. So the original outburst was, oh my God, you're making this group of nuns pay for the morning after pill for their other nuns. I mean, they don't have many other employees. So as you imagine, this created a significant controversy. And the federal government released revised regulations, okay? And these revised regulations, they said, okay, if you are a religious organization, you operate as a nonprofit entity, you don't have to pay for this. Your insurance provider will pay for it in your stead, right? So this was a compromise position released after a lot of controversy. But this didn't satisfy everyone, okay? Why? Because of this phrase right there, non-profit. So originally the accommodation was limited to non-profit groups like the Little Sisters of the Poor, or perhaps Notre Dame University, or Wheaton College, or other groups like this. What about for-profit entities that had religious identities? So this is the crux of the Hobby Lobby case. So a little background first, if I may. We have to discuss the Religious Freedom Restoration Act, or if you want to be cool, RFRA, which is one of my favorite acronyms, followed only by RLUIPA, which is the Religious Land Use Institutionalized Persons Act. So the history of RFRA begins with Mr. Al Smith. He was an employee of the Oregon Division of Employment. He was also a Native American. And part of his religion required ingesting peyote. If you don't know what this is, it's a hallucinogenic cactus. If anyone's used it, don't tell me because you have to sit for the bar soon. I don't want to know. So he, oddly enough, worked as a drug and alcohol counselor. That was his job. And he was also using this peyote, which is a controlled substance, and it's illegal. He took a drug test, which he failed, and he was terminated. And he tried to obtain unemployment benefits, and he was denied because he was terminated. So he tried to say, wait a minute. I have a religious liberty, right? I have this right of free exercise. I should be able to ingest this peyote if I so choose, and the state can't punish me. And in a decision by the Supreme Court, authored by, of all people, Justice Scalia, he said, no, that's not how this works, right? The free exercise clause doesn't give you the right to violate generally applicable laws. If you have a drug law that applies to everyone equally, you cannot smoke peyote or ingest whatever you do with it, right? That's an equally applicable law. And you do not get an exemption from that law if it applies generally to everyone. This proved to be a very unpopular decision and actually led to the signing of something called the Religious Freedom Restoration Act. That's a young Bill Clinton, that's Al Gore and Chuck Schumer. I draw attention to those names because this was originally conceived not as a conservative act, but actually an act favored by liberals. The ACLU backed this. Ted Kennedy introduced it in the Senate. So this was often viewed as a way to bring back religious liberty to really what were minority oppressed groups, for example, Native Americans. This was not viewed as a way for Christian evangelicals to deny birth control to employees. That was not how the law was conceived, but we'll get to that later. Conceived is a very poor choice of word. I shouldn't use that word, actually. So the law itself was RFRA. And it was actually a fairly short bill. It fits on 1.5 pages compared to the ACA, which is like a 3,000-page law. And the key language, right, basically says Congress cannot, no government, state or federal, can substantially burden religious exercise, right? And they can only do this if there's some sort of compelling governmental interest and they use the least restrictive means. It's unclear exactly how this test works. This is probably something approaching strict scrutiny, although we don't know exactly where it falls. By the name of the law, the Religious Freedom Restoration Act, you think they were trying to restore the pre-Smith version of the First Amendment. Although, as the Supreme Court ultimately say, they didn't just restore it, they actually expanded it. And we can talk later whether it's an accurate characterization or not. But the minimum, if a state or federal government, as the law is written, substantially burdens religious liberty, free exercise, right, they need to show that they're acting in a very narrow manner. So in theory, right, would this have resulted in Smith not getting terminated for smoking peyote? Maybe, probably not, but it would have at least given him a shot beyond what Smith gave him. So let's go back to our friends, the nuns, the Little Sisters of the Poor, and they're this charitable group that works and does a good service for seniors, and they provide care for them. So initially, right, they had to pay for the Plan B for their employees, and they didn't want to do this. They objected. So then the Obama administration gave them another compromise. Said, okay, you know what? You don't need to provide contraceptives to your employees. All you have to do is fill out this form, right? And I'll zoom in on this language, right? It says, you know what? I certify that because of my religious objections, I'm a nonprofit. I don't want to provide this, right? The government says, okay, so sign this form, but also you must give a copy of this certification to your health insurance provider, right? Now, you may think, what's the big deal? They're just filling out a form and giving a copy of this form to their health insurance providers. Well, as it turns out, they have a very big problem with this, because in the minds of the Little Sisters, by filling out this form, they're setting to place a sequence of events that triggers the provisioning of various forms of birth control to their employees. And they want no part with that chain of events. Almost like, talking about moral culpability in the religious sense, they are part of this process that leads to these sinful pills being distributed, right? So this case went to the Supreme Court, and actually was an emergency appeal. We've had a lot of those emergency appeals in the last year. And in a unanimous, well, not so unanimous, but with no recorded dissent, the court said, hey, Little Sisters, you don't need to fill out this form. Just write a letter to the government notifying them of your objection. Okay? So this was even before Hobby Lobby was decided. This was an initial compromise. That religious freedom did entail, under RFRA, not being forced to provide these products. Okay, everyone with me so far? All right, so let's go on to Hobby Lobby. Everyone know about Hobby Lobby, the company? Has ever been to one? I had never been to one until a couple months ago. I actually went one just for fun. I was like, okay, I didn't buy anything though. I didn't really have anything to buy. I don't do crafts. I'm from New York. You don't do crafts in New York. You're too busy running away from things I don't even know. So I actually went to a Hobby Lobby. It was very nice. They have them all over the country. It's a craft store. They sell arts and craft supplies. I wouldn't even know what to do with any of that stuff. Actually, kind of a funny story, though. The reason why I went there was I had sent copies of my book to all the justices, and none of them sent thank you. So I wanted to frame my letters from the justices in Hobby Lobby frames. I think there's a certain irony of framing my Justice Sotomayor letter in a Hobby Lobby frame, but I'll let that one go. So one aspect, though, of the Hobby Lobby Corporation is that it's a very religious company, and I'm going to explain what I mean by that. The actual operation of the corporation is infused with Christianity. And this is an actual sign on the door. That's what it says. They're closed on Sundays to allow worship time for their families, right? They have religious counseling for their employees. They play Christmas music year-round. They have various aspects of their company that are infused with religion. In fact, the owners of the company, the Green family, they own the company together as a trust. So basically the entire family's owned, the entire company is owned by a single family. Now, one point I want to make clear, and this got lost in the debate, Hobby Lobby is not opposed to birth control, period. They only oppose 4 different forms of birth control, which they consider as something that prevents, not fertilization, implantation, right? They're okay with stuff beforehand, but once it's fertilized, they don't want anything else after that, right? So of all of the 20 forms of birth control, and I'm not going to list these to you, you can use your imaginations, they only oppose 4, which is Plan B, the morning after pill, Ella, which is an emergency contraception, and 2 forms of intrauterine devices, which are these little rods that you put inside and they release various hormones, okay? So they oppose these 4 grounds, okay? Now, how is Hobby Lobby, a corporation, opposing it? So we have to think about the RFRA law itself. If you go back to the slide before, it says no person shall have their religious beliefs substantially burdened. It says person in there, right? So how do we go from person to corporation? Now this is the key issue in the case. So the Green family, and I think this must be an Easter shot because they're wearing beautiful pastels, right? The Green family is also the board of directors. The company is owned entirely by this family, and it's a fairly close-knit family, as you might imagine. They have very, very nice color coordinations, right? So we go back to RFRA, right? This is the Religious Freedom Restoration Act. It says, government shall not substantially burden a person's exercise of religion. Right, so it's right there, person. How is it that Hobby Lobby, a corporation, can avail themselves of this law? Right, the law doesn't require Mr. and Mrs. Green to do this. It requires the Hobby Lobby Corporation, which is a separate legal entity. Okay, so let's take a trip back all the way back to 2009 with Citizens United, the FEC. I'm sure you studied this case in con law. I've heard about it, or heard it was the worst thing in the world. But in short, a group called Citizens United wanted to make a movie about once and future presidential candidate Hillary Rodham Clinton. And they wanted to make this company using corporate funds, and they wanted to release it within a certain number of days before the presidential election. It wasn't a very good movie. There wasn't much value to it, but it was an aspect of political speech, right? The Supreme Court said, yeah, they can do that. That Congress cannot ban these corporate funds to make a movie a certain number of days before the election. This case didn't eliminate all corporate spending. This case was blown up way more than it should have been, but the actual holding of the case focused on this one movie. But in the aftermath, the justices were tarred and feathered as these corporate shills who were beholden to corporate America, and that the United States of America is going to be owned by the Koch brothers and George Soros, right, and others. All right, so let's go ahead to the Hobby Lobby case. And one of my favorite parts of this case are the signs. Protesters get really creative. So this one was my favorites. If men can get pregnant, birth control will be from gumball machines and bacon flavored. I do like this one. This is not a church. This is not a healthcare plan. She dressed up like a pack of birth control pills, which was nice. No bosses in my bedroom, and I'm sure the Hobby Lobby Corporation would agree with that. They don't want to be in your bedroom because they don't have to pay for your birth control. But I don't think they have the same message. I think they're on different pages. Contraception is my business, and I'm sure Hobby Lobby would agree with that. We don't want to pay for contraception. Do it yourself. Pay for it yourself. But again, I don't think they're quite on the same page. Corporations are not people. This one was my favorite. She actually crocheted a uterus. I do not think she bought the yarn at Hobby Lobby. I was not able to verify that fact. This one was good. Keep your hobbies off my ovaries. Okay, and then we get to all the anatomy lessons. And of course, God's law comes first. Repeal socialist Obamacare, and you need a bagpipe to really accentuate the accentuate the repeal part. Okay, so I love the signs; they're so creative. So one of the fun things to do is whenever there's a big Supreme Court case, the C-SPAN just rolls film on the street outside the court. I usually just watch that. And just watch people coming and going. It's fascinating. Anyway, so we have oral arguments in a Hobby Lobby case. And this was a rematch of the Obamacare case. Now we have, again, Solicitor General Don Verrilli and a wunderkid, Paul Clement, who's one of the most remarkable Supreme Court advocates of our day. If you want to learn how to be a good advocate, listen to his arguments. They are remarkable. His arguments in the Obamacare case is one of the best I've ever heard. So definitely pay attention. So of course, as you might imagine, one of the major arguments in the Hobby Lobby case was, can a corporation actually be protected by RFRA? And this issue was a lot easier than you think. There's something called the Dictionary Act. Has anyone ever heard of it? It's 1 U.S. Code 1. It's on the very first page of the U.S. Code. And it defines different terms. And it defines the term person to include a corporation. Now, I know that says, oh, that's just a simplistic argument. But in reality, much of corporate law applies when Congress says person. You don't specify. So on this front, actually, the justices were not that divided. Only 2 justices said that corporations are not people. That would be Justices Sotomayor and Ginsburg. Kagan and Breyer were kind of quiet on that one, which is a little bit curious. They didn't say one way or the other, but they didn't join the Ginsburg dissent, so whatever. The more important issue was this actually a substantial burden, right? Does mandating the Hobby Lobby provide birth control, these forms, to their employees actually substantially burden their religious exercise. And for the most part, the government didn't fight that one. The government didn't quite concede it, but it was understood that this goes against their sincerely held beliefs. Some criticism, the government could have actually challenged this, saying, wait a minute, I don't think this is a sincerely held belief. I think you provided these things in the past. But the government didn't really challenge that. So the substantial burden one wasn't that much of a difficult pull. The really tough one was about narrow tailoring. And it goes something like this, right? If Hobby Lobby is not providing this, who's going to do it, right? The Affordable Care Act says we want to provide these products to women. They're very important, whatever. If the government's not, if the Hobby Lobby's not doing it, who's going to happen? And interestingly enough, one of the things the court said was, well, wait a minute. You gave this accommodation to Little Sisters of the Poor, right? You said to Little Sisters of the Poor, if they don't want to buy it, they don't have to. Why can't you give the same accommodation to Hobby Lobby? In other words, if the Little Sisters of the Poor can just shift the cost to the insurance company, why can't Hobby Lobby do the same? And this is a place where the government didn't have a very strong response. The one response could be, well, because maybe it's expensive or the market doesn't work that way. But if you have this Religious Freedom Restoration Act, which says you need to do things so as you do not substantially burden religion, then this is a viable alternative. And this is actually, we'll see what happened. But in the end, it didn't go very well for the Solicitor General once again. He had a very tough haul. And walking out of it, it didn't look too good for the government. They were going to lose, right? The question was, how bad were they going to lose? And they didn't lose that bad. It could have been worse, right? So the actual decision itself was released. And this is actually a funny kind of an ancillary issue. There are no cameras in the court. We don't know what's going on. There's no live audio feed, right? So the only way we know what goes on is because of SCOTUS blog and a guy named Lyle Denniston who's reported for SCOTUS blog. And he's sitting there typing in real time. He's listening to the audio saying, Justice Alito has the opinion. So as soon as it was announced that Justice Alito had the opinion, Hobby Lobby, there was a collective, oh man. So all the people who were rooting for Hobby Lobby to lose were like, oh my God. And all the people who wanted Hobby Lobby to win was like, yes. So there was this brief 30-second span where we don't know what Alito said, but it's like, all right, we got this. So this was probably the president's reaction when he heard Alito had the opinion. It's like, oh man. So Justice Alito had the majority opinion for the court. And very perfunctorily, they said, yes, of course, RFRA applies to corporations. That one wasn't a tough issue for the majority. They also said that this is a clear substantial burden. They have this sincerely held belief in life, and they don't want to be terminating it with these various products. So that's an issue there. They also said that RFRA didn't just restore the First Amendment as it existed before the Peyote case, before Smith. What the court actually did was RFRA expanded religious liberty above and beyond what the First Amendment provides. And this is actually a somewhat contested point. And I'm a little bit unclear on this one myself. I think I go back and forth. The court also held, interestingly enough, that this is not the least burdensome way of doing this. If the government thinks it's so important to give birth control to women, they can pay for it themselves. If the government thinks providing these products is so important to women's health, then the government can pay for it. Why are you making Hobby Lobby pay for it? And it's an interesting argument because, of course, the government can always pay for things themselves. The entire point of Obamacare was to shift costs onto the employers. So this was almost a burden the government couldn't escape. Of course, in the end, the government can pay for anything. And if that makes it okay, then that obviates the need for companies like Hobby Lobby to comply. So the court didn't actually say that the government has to pay for it. All the government said was the fact that you can pay for it means there's another way of doing this, right? The fact that the government could pay for these products means we don't need to make Hobby Lobby do it themselves, right? So a lot of people seem to have taken the opinion, which I don't think is correct, to say the government said as long as the government pays for it, that makes it okay. The court didn't say that. The court simply said, here's this alternative which proves you're not acting in the least burdensome manner. This I think, got a little bit lost in translation. Now, Justice Ginsburg wrote this dissent. So here's a pro tip. When she is issuing a dissent, she wears a special garb. So everyone know what this thing's called? Anyone know what it's called? A jabot. Jabot. It's a neck collar, or actually, I made up a word, neck doily. I actually got a word in Black's dictionary. It's going to be in next edition of Black's. For jabot, see also neck doily. She kind of looks like a teacup, right? Yeah, there it is. Yeah. Anyway, so this is Justice Ginsburg dissenting doily. She says she wears this one for dissents because it's very fierce, and this was a fierce dissent. This is, of course, our favorite RBG, right? Yeah. So if you ever go to the court and you see she's wearing the blinged out one, right? She's going to dissent. She got this in a gift bag from, I think, Glamour magazine or some such thing. So Justice, good old Ruthie, right? So Justice Ginsburg had a very, very vigorous dissent, which got memed very quickly because people liked what she had to say and they made memes about it. But she said, listen, of course Hobby Lobby has their beliefs, but when they're foisting their beliefs on their employees, that becomes a problem. Now, a little pushback to this one, RFRA doesn't protect the rights of employees or employers. It says religious beliefs can't be substantially burdened, right? No one was claiming that the employees' rights were burdened because of having this beliefs foisted upon them, right? What the problem was, the government was mandating that Hobby Lobby violate their beliefs. So I think this is almost a non sequitur. But interestingly, the government made this argument, which I think is a real stretch, that Hobby Lobby was actually seeking a violation of the Establishment Clause. What do you mean? Well, by giving Hobby Lobby an exemption providing these birth control pills, Congress was actually establishing a religion, that they were actually making a religious doctrine by carving out this exception. This made it into a footnote in the SG's brief, which I thought was very odd. The court didn't even touch it, which I think was probably the right move. Justice Ginsburg also made another point by saying, what happens if your religion opposes vaccines? For example, Christian Scientists, right? They do not believe in vaccines. Or what if your religion opposes the minimum wage? Or what happens if your religion, I don't know, requires you not hiring black people in your office, right? So I think these are all fair points, but there was really no evidence this ever happened before. In fact, the first time this actually happened was with something as pronounced as the birth control mandate. Justice Ginsburg was able to cite 2 cases by my count where someone tried to cite religion as a reason why they couldn't hire a black person in their office. These were 30-year-old cases from state court that had like almost no precedence following them. So these are real outliers. So I think these are fair points in the abstract, but I haven't seen enough evidence that these are actually legitimate problems. And Justice Ginsburg was worried the courts waded into a minefield, and we'll discuss this minefield in a moment. So, of course, the pro-life crowd was ebullient. They were high-fiving. She looks ecstatic. The other crowd who did not like Hobby Lobby were enraged. This was my favorite cartoons, very crafty, right? This one's good. Rubber stamps, you just denied. And there was this fear, which I think is somewhat unfounded, that all these corporations would suddenly identify religious identities, and then you have Walmart and Microsoft and all these other companies that can get around employment laws. I think this fails very quickly because it's not very sincere for these companies to suddenly identify religious beliefs. Hobby Lobby has found it with its identity. They've had this identity for almost 30 whatever years. Also, these are all publicly traded companies, right? What makes the Green family so unique is that it's privately held. Although they have a couple thousand stores, right? It's privately held, and all the members of their board have effectively the same religious beliefs. Shareholder law, right? If you have a corporation with thousands of shareholders across the country, the odds of finding a single set of religious beliefs is impossible. So corporate law really prevents us from going too far. In fact, the court's decision said this is limited to, quote, closely held corporations, right? They didn't define what a closely held corporation is, although I think a good measure might be an S corp versus a C corp, right? If you're taking corporate law, like privately held versus publicly held. But again, the court did not define that line. So I think these fears of companies, becoming puritanical and dropping the Plymouth Rock and kicking rid of the birth control pills, I don't think that's very likely to happen, but it might happen at the margin. One aspect, though, that's interesting that spawned is this memeing or deification of Justice Ginsburg as the notorious RBG, of course. And she's actually taken to introducing herself this way. She was doing an interview with Jeff Rosen at the Aspen Institute a week ago, where she said, "We're welcoming Justice Ginsburg," and she goes, "Notorious." So of course, there's the notorious B.I.G. in case you didn't get the reference. There it is. Yeah. So actually, Katie Couric asked her, it's like, Ginsburg was like, yeah, my law clerks have to explain this to me. So now she knows who Biggie is. Although really, Ginsburg's from Brooklyn. She should be a Tupac fan. I don't quite get that. Right. I don't know. She's getting her coast mixed up. So, but didn't end too well for either Biggie or Tupac. So perhaps she should find other icons. And there are all these great memes and all these it's basically Beyonce lyrics with Ruth Ginsburg in the background. And she became this galvanizing feminist force, which is remarkable. she actually is a cancer survivor, so I will give her this one. She is quite a survivor. She actually has a personal trainer, and she can do 10 push-ups. She's 81. She's in better shape than some people in this room, I bet. She works really hard, and her health has been an issue, but she keeps in very good shape. In fact, Justice Kagan is using the same personal trainer as her, and she's getting in shape too, working on her fitness. I'll let this one speak for itself. But all this beautiful deification and adulation for Justice Ginsburg, I think, has a very negative consequence because it obscures the fact that there are legal issues here. When it becomes an issue of this feminist justice versus conservative justices, it blurs what's actually going on. I own this. I own this shirt. And I think at a certain point, it becomes difficult to separate Justice Ginsburg from the notorious RBG. And it seems she herself was having some difficulty separating the two. And when she's now a cause celeb, right, and she's like this galvanizing force for the women's rights movement, it becomes difficult to actually look at the legal issues in the abstract. And when you actually start critiquing Justice Ginsburg, it's seen as critiquing women more broadly. And you've heard of a war on women thing. I don't subscribe to that, but it does become difficult of a Hobby Lobby when you have this in the backdrop. And for example, when the Daily Kos puts out things like this, the 5 justices who undermine women's choice, they're all men. And that became the meme. In fact, Harry Reid, not the brightest bulb, said 5 white men deprive women of the right to birth control. 5 white men. That might come as a surprise to Justice Thomas. Anyway, but the meme was, the 3 women, Ginsburg, Sotomayor, and Kagan, and they were there, fighting for women's rights, and you have this theme over and over again. By the way, this portrait was done of the 4 women justices. I don't know what the painter had against Justice Kagan. She does not look good in this painting. I really feel bad for her. Sotomayor looks fierce. She looks really good. Kagan looks very dumpy and frumpy. It's not flattering. I really feel bad. I can't imagine she liked that. Kagan's portrait at Harvard Law School is very nice if you want to go to a good portrait of her. Funny story. I don't know if this was deliberate, but when she went to the unveiling of her portrait at Harvard Law School, she was wearing the same thing as she was in her painting. Kind of creepy, but it might have been inadvertent. I don't know for sure. But what about the other guy? What about Justice Breyer? So, of course, Dahlia Lewis had to back clean up and call him the 4th feminist just so he wouldn't feel left out of the club. But he is a white male. And this says, where is Justice Breyer's Tumblr? I guess he doesn't generate the same verb as RBG. So that was a Hobby Lobby decision. I'll wrap up in a moment. But fascinating, usually when the Supreme Court term finishes, they're done for the summer. Things get quiet. But not this year, no. Not 3 days after Hobby Lobby decided, we got a follow-up case involving Wheaton College. Wheaton College is a Christian university in Illinois, and they had been challenging this contraceptive mandate for a while. Now, basically, what they were seeking was the same accommodation that the Little Sisters of the Poor got, right? They were trying to say, listen, we don't want to have to provide these pills to our employees, okay? So you would think that this case would come out the exact same way as the Little Sisters of the Poor case. They're a nonprofit, whatever. And in fact, it did. But what happened was it generated vigorous dissent by 3 justices. So the majority effectively said the same thing they said in the Little Sisters of the Poor case, right? You don't need to provide these contraceptives. Just notify your insurance carrier, and then they'll take care of the rest, right? But it occasioned a very vigorous dissent by Justice Sotomayor, who basically called the court out for being hypocritical, right? Sotomayor said, just 3 days ago, right, you told Hobby Lobby that the accommodation we worked for the Little Sisters of the Poor was okay, and now you're saying that it might not be okay. I invite you, and I know this might be a little hard to read, but this is the Little Sisters of the Poor order, and this is the Wheaton College order. They're verbatim. They're almost identical, right? Nonprofit organizations that hold themselves as religious. Nonprofit organizations that hold themselves as religious. Applicants need not use the form. Applicant need not use the form. They need not send copies. They need not send copies. So effectively, the exact same order was issued by the court in the Little Sisters case as it was in Wheaton College. But the dissenters thought that this was disingenuous because the Hobby Lobby decision had basically changed the dynamic. I'll leave you with that, and you can make up your own minds. So after Wheaton College, the Obama administration released another compromise. Okay, under this new compromise, no one, not the nuns, not Hobby Lobby, is required to provide birth control. All they have to do is fill out this form, right? And then, I'm sorry, they don't have to fill out a form. They have to send a letter to their insurance company saying, we don't want to do this. As you may imagine, they're still not happy. So Hobby Lobby and Wheaton College and the nuns have all challenges saying, we don't even want to fill out a letter to the government saying we object to this. I mean, they filed federal lawsuits in court, which is a pretty good indication they oppose this, right? But they actually are opposing this. And there was actually a district court decision, I think, a week ago in Florida, which basically ruled in favor of involving Ave Maria, that was it, involving Ave Maria, basically ruling in favor of the challenger, saying that they don't have to do this. So this would very well make it to the court one more time. I don't think they're going to win this time. I think sending a letter to the government saying you oppose something is a fairly small burden. I really don't. I think they're pushing their luck. And they might get a decision that does not work out well for them in the end. I don't think they're going to win this one. But this issue will keep going. So I'm going to stop here as we have some time for Sir Conkle for some questions. But I thank you so much for your attention, and I look forward to your questions. Thank you so much.
Thank you. Can we shut this off, or I will put the?
Oh yeah, sure.
Sure.
Just press.
Can I mute it?
Yeah, you can.
Blank.
There we go.
I'm trying.
I know I can.
I know. I struggle with this all the time. There we go. Oh,
Yeah, there we go.
there we go.
Good.
Thank you.
Thank you, Professor Blackman. That was very interesting. I just want to offer a few comments and then have plenty of time for questions. Just a couple of comments, just specifically in response to Professor Blackman. A little bit more complexity in terms of the Dictionary Act. The Dictionary Act talks about a person includes a corporation, but it also says unless the context otherwise requires. So basically, the dissent by Ginsburg says the context of RFRA does otherwise require because a corporation cannot exercise religion. In any event, we could talk more about that if that comes up in questioning. Secondly, I think the Obama administration was in fact contesting substantial burden, and one of the arguments made by Ginsburg for all four dissenters was that in fact the connection between providing the insurance coverage on the one hand and the termination of a post-fertilization of life was simply too attenuated. Ginsburg bought that argument, basically saying that that is not a substantial burden. And one of the real key issues raised by this whole line of cases, right on Hobby Lobby, Little Sisters of the Poor, Wheaton College, the new challenge from the Ave Maria, is the issue of when complicity counts as a viable religious objection. It basically, to what extent can someone object on the ground that my doing something is somehow facilitating someone else doing something that I regard as immoral on a religious basis? How far can you stretch that complicity claim? And that's directly raised by these most recent cases where objectors are saying we can't even write the letter to the government without triggering complicity with what we find to be wrongful. I want to get back to that just a little bit more in just a second. And then in terms of the least restrictive means requirement, basically, as I read Hobby Lobby, especially Justice Kennedy's critical concurring opinion, and these interim orders in cases like Wheaton College, the Supreme Court, and this I agree with Professor Blackman's final comment on that I think these most recent challenges may not succeed. The Supreme Court is, I think, especially Justice Kennedy at least, is attempting to craft their own sort of compromise, basically a compromise in which religious liberty objectors can be accommodated, but women employees still get their contraceptive coverage through the insurance company. Whether you fill out the form, whether you write a letter to the government, somehow the government is advised that you have your religious objection, and the government is then expected to work through the insurance company to have the insurance company independently provide the contraception coverage. And the financial theory of that is that contraception actually saves money because you have fewer pregnancies. So basically it would work financially, or at least the Obama administration so contends. But I want to comment just a little bit on the case that Professor Blackman, actually just 2 days ago, was this Florida court's decision. And it's a little bit more I didn't even understand this myself until I read the district court's order from 2 days ago. What the Obama administration provides in its accommodation following Wheaton College is as follows. Okay, so Wheaton College says if you send a letter to Health and Human Services, that's good enough for Wheaton College, as it was for Little Sisters. There's another complication of Little Sisters if you won't get into it, and that is that Little Sisters, unlike Wheaton College, involved an insurance company called Christian Brothers. So you got Christian Brothers, you got Little Sisters of the Poor, the Obama administration against these various groups. It could make for some colorful commentary. But basically, the argument that Sotomayor made in Wheaton College was that Little Sisters is different because, and this I do not understand at all, under obscure provisions of ERISA, Christian Brothers is a church plan, and they wouldn't have to provide contraception coverage anyway. In any event, if you can figure that out, please send me an email so that I can figure it out. In any event, okay, the Obama administration responds to Wheaton College in August and says, as well as responding to Hobby Lobby, here's what you have to do. An eligible organization may notify HHS in writing of its religious objection, including the name of your organization, and state that you have a sincere religious objection. In fact, this was which was this college? Ave Maria. Okay, Ave Maria is okay with that. They're okay with that much. They're not saying we won't even send a letter. They will send a letter. They'll say we'll send the letter. We'll say we object. We are a religious organization. But the interim regulations of the Obama administration go further and say you also need to tell us in this letter the plan name and type of insurance coverage that you have. You also need to tell us who your insurance company is or your third-party administrator and give us the contact information. That's what they're objecting to, okay? Basically, they're saying, we'll send you a letter, we'll object, but we won't provide this additional information, contact information. That makes us complicit. And I think the question really is that just cutting the mustard too finely? Is that basically going to test the patience of someone like Justice Kennedy, basically saying at a certain point, is this in fact getting to be ridiculous? The converse position, on the other hand, might be, and I don't know the answer to this either, among these 3,000 page Obamacare and regulations following it, what are the rules as to employer reporting generally? In other words, does the employer have to report to the government anyway who its insurance company is, what kind of a plan do you have, in which case then maybe the Obama administration doesn't need to ask in this order, you tell us the name of your insurance company. Maybe they have that otherwise in their records through other reporting, in which case they could perhaps be satisfied merely with the letter. But this idea of complicity, the reductio ad absurdum is, we're complicit if we simply assert our religious objection. Because if we assert our religious objection, that sets in motion a process in which the government will try to find out who our insurance company is and ultimately provide the insurance coverage that we object to our employees through some separate route. And I frankly think that just as a matter of sort of practical, I guess, realpolitik of guessing what the Supreme Court's going to think of that argument, I think they would reject that. Whether they would basically permit this sort of fine-grained objection that Ave Maria is making, a little bit more of an open question, but I do think, I agree with Professor Blackman that it's really sort of testing or might be testing the patience of the Supreme Court once it gets there, or at least testing the patience of Justice Kennedy. The other, I guess the only other comment I might make, and that is just simply to comment on sort of the shifting politics of religious freedom. Professor Blackman talked about it a bit. I mean, sort of in the heyday of religious exemptions, it was Justice Brennan, liberal icon of the Supreme Court. RFRA was actually supported not just by the liberals, but by a broad array of religious conservatives as well. So it was sort of a consensus approach that this is a good thing to have religious liberty, including religious objections. Then you have, I think, Obamacare. Obamacare, you have basically the left side of the spectrum is basically in favor of Obamacare. The right side of the spectrum is objecting with a combination of things. Federalism really linked to libertarianism, I think, quite strongly, and religious liberty is sort of part of that package. And now you've got the issue of same-sex marriage on the horizon and potential objections to that. So basically you have this, I find unfortunate, sort of politicization of religious freedom that tends to suggest that if you're in favor of it, you're conservative, and if you're liberal or progressive, you got to be against it. In fact, there's an interesting article out on the wire, at least on SSRN, from a Minnesota professor, basically saying, we need a progressive, saying we need to make the progressive case for religious liberty, and in fact for Hobby Lobby itself, in part on the theory that as a matter of corporate law, which is apparently his specialty, there ought to be room for socially progressive corporations that don't simply honor the bottom line, that build other values into their corporate identity and what they do as corporations. And basically there ought to be room likewise for religious corporations to likewise. That author's name, if you're interested, is a guy named McDonald, Brett McDonald. In any event, I will leave it at that. And again, thanks to Professor Blackman, and plenty of time for folks to ask questions.
Please, so please welcome your questions.
Yeah. Go ahead.
Yes.
So I'm curious about what you think about the makeup of the court. It's pretty much only Catholic and Jewish, and I think one of the Jews might actually be an atheist. So it's
Are you talking about Justice Breyer?
I'm not going to say anything, but
Okay.
I want to say like 40 to 50% of Americans identify under a Protestant branch, and almost all the Protestants are okay with birth control. So Protestant doctrine, that is. If we had a couple more Protestants in the court, do you think that would have changed how they would have seen things?
No, I don't think that matters much. I think it's actually quite grotesque to characterize the justice based on their religion. So I don't particularly like that question. What I will say, an interesting issue is that if a majority of people, you mentioned same-sex marriage, I mean, at this point, we're effectively at a tipping point where a majority of Americans support same-sex marriage, right? And that includes people of varying faiths. Does that make a difference of how states will go ahead or courts will go ahead and invalidate it? I think that's a much more thing. I think birth control is not the issue. It's making people pay for birth control is the issue. I think birth control has been effectively an accepted issue even before Griswold. I mean, Griswold was a set-up case because they had to basically make them arrest them. They tried to get arrested so they can actually get a test case because Connecticut wasn't even enforcing the law. So birth control is not the issue. It's making people pay for birth control is a separate issue. Yeah.
If a female Hobby Lobby employee uses her salary in the company to go buy Plan B and Hobby Lobby finds out about it, can they say that that makes Hobby Lobby complicit?
No, and in fact, what's interesting is that a number of these Christian companies have special health savings accounts so they can use it for whatever the purpose. For example, AutoCam, which is a company, I think they were in Michigan, they set up a special, I think it was either $1,000 or $2,000 health savings account, which they could use for whatever they wanted. They can go buy birth control, go pay for an abortion, whatever. That's their fine. In fact, Hobby Lobby actually pays extremely high salaries, well above the minimum wage. In fact, their starting salaries are double the minimum wage. So they say, once I give you your paycheck, you can do whatever you want with it. We don't want to do it ourselves. So the issue of complicity is very difficult to define, and I don't have any bright lines. But at least that's how Hobby Lobby views the issue.
Any other questions?
Other questions? Come on.
If not, we're just going to thank you, Professor Blackman.
Thank you so much.
And thank you all for coming and hearing him speak.
Thank you.